Thank you. Thank you, Annie. I greatly appreciate it. Hi, everyone. My name is Judy Matthews, and I'm the president of the Altadena Chamber of Commerce. We are excited to have you join us for a special presentation that we are hosting in partnership with the Pasadena Small Business Development Center. Today, our human resource expert, Xiomara Palma, will be presenting on 2023 employment law updates that every small business owner needs to know. Welcome and thank you, Xiomara.
Good morning, everyone. Thank you, Judy, for that introduction. My name is Xiomara Palma. I'm one of the advisors here with the Pasadena City College SBDC, and it's a pleasure to be here with you all to do the 2023 employment laws update. Can everyone see my screen? If you can give me a thumbs up.
Yes.
Perfect. Awesome. So before we get started, I would like to introduce the Small Business Development Center for those of you who may not be familiar with our services and what we do. The Small Business Development Center is a proud partner with the Small Business Administration, and I would like to play a small video that tells you a little bit more about the services we provide and who we are. So here we go.
The audio is bad.
Xiomara?
There's no
Yes.
audio.
I think they can't hear the audio coming from the video.
Oh, okay. Let me. Are we having issues with the video?
Yes, there's no audio coming from it.
Oh, okay.
Yeah.
That's odd. Hang on one second. Let's see. Rewind. I'm going to do subtitles with it as well. Okay. I'm going to try to play it one more time. Let me know if it works.
Yeah, it's still not working.
You need to go to your advanced sharing options and select share computer sound.
Okay.
If that doesn't work, can you talk us through the?
Yeah, I can just do the introduction.
Right.
So basically, the Small Business Development Center, as I mentioned, is a proud resource partner of the Small Business Administration. We have over 1,000 locations in the United States, with 9 locations here in LA and Ventura counties. One of those locations being located at Pasadena City College, here in the city of Pasadena. And the services we provide are at a free cost, no cost to any of our clients, whether maybe a startup or already an established business looking to grow their business. We provide services, anything related to business administration. So anything about financial planning, funding, human resources advising, accounting, anything a business could need to be administered. Those services are provided to everyone. We do have a team of experts, and so if you ever need any resources or need assistance with any questions, feel free to reach out to any of us, and we will be more than happy to advise you on your needs. A little bit of background on myself. As I mentioned, my name is Xiomara Palma. I've been doing human resources for over 15 years now. I'm also a small business owner of a consulting firm called Solve It HR. I mainly work with small business owners and helping them be in compliance with employment laws and manage their employees. And I'm happy to also be an advisor here with the SBDC. And as I mentioned, if anyone ever needs any assistance in regards to employment law or managing employees, feel free to schedule a consultation by reaching out at sbdc@pasadena.edu. The agenda for today, what we're going to talk about, mainly give you an update on several different areas of employment law. We're going to go through wage and hour laws, laws pertaining to benefits, workplace safety, and a few other laws that have gone through this year, 2023. We'll wrap it up at the end with a Q&A session. And if you do have questions, feel free to drop those questions in the chat. Annie will be monitoring those questions, and I'll be checking in with her throughout the presentation. So do feel free to drop your questions in the chat there. A brief disclaimer before we get started. As many of you may be aware, human resources is ever evolving, and the topics that I will cover today are current as of today, February 23rd, 2023. And they are intended to be for best practices and informational purposes, and not as legal advice or recommendations for anyone. All right, with that being said, let's dive right in. First up, the transparency law that went through this year, SB 1162, and this law applies to employers of all sizes at different levels. So starting with the part or the layer that applies to all employers, which is all employers are now required to provide a pay scale to current employees upon request for the position that they currently hold. They are also required to maintain records of job title and wage history for each employee, not only for the duration of employment, but in additional 3 years after separation of employment. And failure to keep those records can result in a rebuttable presumption in favor of the employee, meaning that if an employee ever files a claim against you or against an employer for failing to provide the pay scale, then, and if you don't have records to prove that you have provided the information or you have retained the documentation that you have that has been requested from you, then likely the employee will win or prevail in those situations, in those claims. So very important to keep those employment records up to date. I know many employers use third-party administrators to keep payroll records. And something to be mindful of when you're switching payroll companies is to also make sure that you extract all the records that have been placed into that system so you can retain that information should anyone ever request information or file a claim against yourself. The second layer of the law applies to employers with 15 or more employees. Now, this layer requires that employers disclose a pay scale on any job advertising, and also the same as the requirement for all employers that current employees should be entitled to receive also a pay scale upon request. Now, if employers engage a third party to post job ads, they must also provide the pay scale to a third party to include it on the job ad. And one question that comes up about the employee count is, do part-time employees count? Do full-time employees only count? It actually is any time that an employer reaches 15 employees in their payroll system. So at that moment, this is when it should trigger the law and compliance with this requirement. One thing to keep in mind is that the law actually does not include bonuses, commissions, or additional tangible benefits to be disclosed on the pay as part of the pay scale. So these are additional items that are not required to be disclosed, but many employers still disclose those requirements in order to attract or retain talent. But just as a reminder, it's not a requirement. Penalties for non-compliance with this requirement can range from $100 up to $10,000 per claim. So again, something to be mindful of in regards to being in compliance with this. The third layer of the law applies to employers with 100 or more employees. And this law mainly has to, or this section mainly has to do with the pay data reports that are required of employers with 100 or more employees. A few years back, we had a law that went through requiring that employers with 100 or more employees submit pay data to the local department, the DFEH, the Department of Fair Employment and Housing. Now they've changed their name to the California Civil Rights Department. So employers were required to submit this information to them, and many employers were using the federal report that already required them to submit the same information in order to comply with this new requirement here in California. Now, what this law did is that it amended the requirements to exceed what is required at the federal level. So now employers, in addition to what is already required, they must also include the mean and the median for each job category, broken down by race, ethnicity, and sex. So meaning that a lot of employers, or now employers, cannot submit the EEO-1 report that they used to submit, that's the federal report. In order to comply now, they have to do an additional report to satisfy the requirements here in California. And if employers have multiple locations, a separate report is needed to be submitted for each one of those locations. One thing that also did change is the due date when this report must be submitted to the California Civil Rights Department. Previously, it used to be March 31st of every year. Now the requirement has changed to be the second Wednesday in May as the deadline to submit the report and be in compliance. And with the new year, we also see a change, or most of the time an increase, to the state's minimum wage. This year is no exception. We have the minimum wage increased to $15.50 an hour for all employers across the board. That is a $1 increase for smaller employers, those with 25 or less employees, who were required to pay minimum wage at a rate of $14.50 an hour. So that is quite a big jump for them. Larger employers, those with 26 or more employees, were already at $15 an hour as of last year. And one thing to be mindful too is that whenever the minimum wage increases, it also triggers an increase for salaried employees. So anyone being paid as salary exempt automatically gets an increase as well, because the minimum salary you can pay someone as salary exempt is double the state's minimum wage, or currently it's $64,480. In addition to you paying them a salary in order to properly classify someone as exempt, they also need to meet other criteria. They need to meet a duties test, meaning that they must perform job duties that are or fall within the categories that the law allows them to be able to perform exempt work, and meaning that they are exempt from overtime and a lot of the wage and hour laws that apply to hourly employees. Not only that, but also there is a monthly minimum salary that must be paid to salaried employees. So that current salary is $5,373 with 33 cents. And that also must be met in order to comply with the law. Now I'll check in quickly with Annie to see if we have any questions, because I know this slide tends to trigger some questions sometimes.
Hi, Xiomara. So far we don't have any questions in the chat. So we can continue. I'm sure some more questions will come up as we get further into the presentation.
Okay, great. In addition to the state's minimum wage, we also have local city ordinances that require a minimum wage. And this is all throughout the state of California. There are a lot of ordinances in the northern side of the state, but those that apply, or those cities in Southern California that do have minimum wage ordinances, are the city of Malibu, West Hollywood, Los Angeles, Pasadena, Santa Monica, and unincorporated LA County. So all those cities do have a minimum wage that is required to be compensated to employees for performing work within the geographic boundaries of the city. Most of the ordinances do require that if an employee performs at least 2 hours of work within the geographic boundaries of the city, they must be paid the local city's minimum wage. So for example, if you do have someone that goes and meets with one of your clients, let's say in Malibu for 3 hours, you will compensate that employee the Malibu minimum wage of $15.96 for those 3 hours that they perform work there. So it's important to keep track of the time that they perform work within these city boundaries, as well to be in compliance with the requirements, the minimum wage requirements. Another area of wage and hour laws or regulations that get a lot of people in trouble is the meal and rest periods area. This is the most contested area in wage and hour law. And actually, I would say in most of the employment law, every other year we see some lawsuit or a case that makes changes to the meal and rest period requirements. Last year was no exception. So last year we did have a lawsuit, couple lawsuits actually challenging meal and rest periods. One of them was related to an employer having a payroll system that rounded the times that employees clocked in or clocked out for meal and rest periods. So for example, if an employee took a 28-minute meal period and they would clock back in at 28 minutes, the time clock would round the time and actually make it 30 minutes automatically. The law found this to be unlawful and not in compliance with the requirements of the law. And it also, as many of you know, the requirement is that an employee must be provided a minimum of an uninterrupted 30-minute meal period for every 5 hours worked. So this rounding policy or rounding procedure this employer had violated the law. And not only that, but employers are also required to pay premium pay, or previously known as a penalty, for any time an employee had an interrupted meal period or was prevented from taking one due to work demands. So this premium pay or penalty was compensated at 1 hour of the employee's base rate. So if you were paying someone minimum wage, say $15.50, and they had work prevented them from taking a meal period, then you would compensate them an additional hour for the day at their base rate. Actually, the law did change and updated the rate that they should be compensated. So now it's not the base rate, but it was changed to the regular rate of pay, meaning that all compensation that is provided to the employee needs to be calculated, and then you divide it by the amount of hours they worked to come up with their new hourly rate at which you will be compensating for the premium meal period rate. So that was a significant change, and it actually applied retroactively. So one thing for employers to be mindful of is to audit their payroll data and any missed meal periods to go back and ensure that you are in compliance with this new requirement. And best practice also to refrain from rounding. And rounding is actually not allowed, or the courts have ruled quite against rounding. So that should not be the practice that any employer should engage in order to avoid any lawsuits or any claims against them. Another requirement is that you do have to keep accurate records for not only meal periods, but also for payroll records, timekeeping records, time cards, things like that. You need to keep those for up to 4 years. So ensuring that you have that information as well to make sure that in case of an audit, or in case worst case scenario, knocking on wood, in case of a claim or a lawsuit, you do have the information to protect yourself from any claims there. An additional laws, so now laws that relate to benefits for employees. And we did see quite a few go through. We have AB 1949, which applies to employers with 5 or more employees, and it grants up to 5 days of bereavement time for an employee who has worked for an employer for at least 30 days. And this employee can take bereavement time for family members to include spouse, child, parent, sibling, grandparent, grandchild, domestic partner, and parent-in-law. The employees don't have to take the time consecutively. They have up to 90 days or up to 3 months to be able to take those 5 days. They are not required to be compensated, but if an employer already compensates for the time, for common practices about 3 days, most employers compensate for bereavement time. Employers can continue to compensate that time, and then the rest of the days could be unpaid. However, employees can tap into any available balances they may have, such as vacation, paid time off, or sick time, to be able to get compensated for those days the employer would not compensate. This time, bereavement time, is protected. An employer cannot discriminate, interfere, or retaliate against an employee for taking the time. And the employer does have the right to request documentation to verify the need for bereavement time from an employee. However, they must keep this information in strict confidentiality. So obviously only the person requesting it or the custodian of records should keep access to this information, and it should be kept in the log cabinet where no one can access that information. We also did see the expansion of family members under the California Family Rights Act and the Healthy Workplaces, Healthy Families Act, aka known as the Paid Sick Leave Law. Normally, employees would be able to take time off either for themselves to take care of themselves due to a medical condition, or to care for a family member, which would include the same family members we just saw for bereavement time. But now this year, there is an expansion of those family members. Employees can actually have a quote unquote designated person that they care for to be able to take sick time and be able to take time under California Family Rights Act. There is a slight difference in the definitions under the two laws. Under the California Family Rights Act, it's defined as any individual related by blood or whose affiliation with the employee is the equivalent of a family relationship. And the definition under paid sick leave is basically a person identified by the employee at the time the employee requests sick time. So it could be they don't have to notify you in advance, but at the time that they are calling in sick, they could just say, I'm taking time to care for, for my cousin, or to care for my uncle. That's now covered under the law. Employers can limit the amount of designated persons that an employee can have every 12-month period. So it could be one person every 12-month period. And then you can count that 12-month period in a myriad of ways. You could do it by calendar year. You could do it from the date that the employee requested the time. So just whichever way you use to normally calculate time off under California Family's Right, that's the same method you would use to calculate an employee that having a designated person for that 12-month period.
Hi,
We
Xiomara.
all, yes,
I was wondering if we can take a pause to answer a couple questions before we move forward.
absolutely.
Okay, so this is going back to the minimum wage increase. We have a question from Barbara. Do part-timers also have to meet the $5,000 minimum?
So a part-time employee would not be able to be a salaried employee. So salary employees are normal, would have to be someone who is a full-time employee. Anything outside of that anyone needs to be paid either hourly or, however the method you're using to compensate within the law. But a part-time person could not be classified as salaried exempt to meet, for purposes of meeting the criteria under the regulation.
Okay, great. We have a couple questions from Wendy. The first one, I think, goes back to the local ordinances minimum wage. So she asks, my address on the lease and according to the post office was in Pasadena. But when I applied for business licenses and permits, I fall under unincorporated Los Angeles area. Which ordinance should I follow for minimum wage?
So the business address is in Pasadena, but when she filed for everything else, is unincorporated Los Angeles area. So yeah, so this is where it gets tricky. I love this question. So it would have to be, in order to comply, it would depend on where the employee is located. So for example, if you have an employee, so regardless of the employer's address or where the employer is located, what really matters is if the employee has performed work within those geographical city boundaries. So if you're located in Pasadena, or let's say you're located in unincorporated LA County, but your employee is working remotely in Glendale, that's not going to apply to you. But if your employee actually does perform work within the geographic boundaries of unincorporated LA County or Pasadena, then that is when it's going to apply. So it really depends. It really depends where the employee is going to be performing the work.
Okay, great.
Even if they work remotely, let's say if they work remotely and they live in Pasadena, then the Pasadena ordinance would be applicable at that time.
Okay, and I think just to add also, Xiomara, is it true that if you have an employee that performs services, just say they have to travel outside of where the business address is located, so just say the business address is in Pasadena, but they have to travel to San Bernardino for a job. How would that apply as far as minimum wage?
Yeah, so if they live in Pasadena, or they're commuting from Pasadena to San Bernardino, then you would not apply the Pasadena. Well, hang on one second. Let me think about this. You would pay. So once they're traveling outside of Pasadena, the minimum wage would not be that minimum wage would not be applicable to them. But so as long as they're performing work, meaning that they are actually traveling and being located in Pasadena or traveling through Pasadena, that is when it's going to be applicable to them. But once they arrive at the location or their destination outside the geographic boundaries of Pasadena, then that's no longer applicable to them. Unless, I mean, every city ordinance has, there's some commonalities across them, but every city ordinance also has like certain certain caveats or certain specifics. So, I would suggest, like, if you do have employees that work within these geographic boundaries, that you get acclimated with the actual ordinance itself, because most of them are pretty similar, but there are some differences between some of the requirements that they do have.
All right. So one more question from Wendy, and we have a raised hand from Rebecca. So second question from Wendy, do we have to track breaks or require employees to clock in and out on breaks? My understanding is that if there is a lawsuit, it is the employer's responsibility to provide evidence that breaks were provided. So if we are not tracking breaks, how do we provide proof in court?
Yes, you are correct. So it is the employer's responsibility to track the time, not only to grant it and relinquish control over the employee's time, but also to track it. So a lot of payroll systems fail to comply with this, or fail to do so. They're very good about tracking the meal period, the lunch break, but not the actual rest breaks, the 10-minute rest breaks the employees are entitled to. So one way you can do it is like by keeping a log of each employee and when they actually went to break and when they came back, and having them sign off on it on a daily basis, or having one of your supervisors do it. I'm not sure how big your operations is. Just keeping that log. Another way you can do it is by including a disclaimer on the time cards that says, I'm making the employees sign off on it, and to acknowledge that they certify they were provided their meal and rest periods, and they don't have for that time period, they don't have any missed meal periods or missed breaks. That's another way you can do it. But it is the employer's responsibility. I know of only one payroll system so far that actually does track the time the employee takes the break. It doesn't deduct it like it would clock them out for their meal period, but it does track the time that the employee clocked in and or the employee goes and comes back from break.
Okay.
I hope that answered the question.
So one more before we continue with the presentation. I know Rebecca's had her hand up for some time.
Hi. Yeah, I wanted to address Wendy's first question because I know where she is. There's a large portion of Pasadena that's actually unincorporated and not part of the city, and is actually considered to be part of Altadena. I think she falls in that area. So I think she would need to follow the LA County guidelines, not the city. Even though her zip code is in the city, she's in an unincorporated area. So that would be LA County.
Thank you. Yeah, it's quite confusing because my address says Pasadena, but I know I'm in Altadena, and it's just like, okay, where do I go? Thank you, Rebecca.
Oh, you can, there's maps too, if you want to see where the break off. If you look up for maps of Altadena, you can see where the unincorporated areas of Pasadena are. And I think you follow from that. Yeah.
Thank you.
Sure.
Thank you, Rebecca, for sharing that.
Yes, thank you for sharing that. We have shared the link to where you can actually see where you fall in previous webinars. So we'd be happy to share that with you as well, so that you can enter your zip code, and it actually will tell you what city or what geographic boundaries you fall under. So we'd be happy to share that with you at the end. All right, so moving on, CalSavers. So previously, employers were required to register with CalSavers, and it was done in different layers. So those with 100 employees, those with 50, and then it trickled all the way down to employers with 5 or more employees, which were required to register by June 30th of last year. Now we had a new law that went through that expands that requirement to employers with at least one or more employee. And they have until December 31st of 2025 to be able to register with CalSavers. And there is a penalty if employers fail to do so, $250 per employee as imposed by the Franchise Tax Board. And if you receive a notice, or if an employer receives a notice and they fail to register within 90 days of that notice, there is an additional $500 per employee penalty that they can incur for not complying with that. One thing to keep in mind is that the law excludes business owners. So if you're also an employee of your business, you're not required. This does not apply to you, but it's something that you do need to comply. Even if you provide a retirement plan, you actually already need to register with them to let them know that you already are in compliance as well. We did see a new law that passed this year that's going to go into effect as of 2025. Which is going to be increasing the current wage replacement benefits that are paid to employees under paid family leave and under state disability insurance. It's going to go up to 90% of the employee's wages. Currently, it falls between 65 to 70% of the current employee's wages. There is a grant for small businesses to benefit from or to offset this increase or having employees go when they have employees go on leave. For employers with 1 to 50 employees, it's a grant for $2,000, and those with 51 to 100 is $1,000. And this grant is designed to cover for costs when employees go on leave for cross-training, hiring, job advertisements, any costs associated with the employee having to cover for when an employee goes on leave. The eligibility requirements is that the employer employ between 1 and 100 employees in California, be registered to do business in the state of California, be in an active status with the Office of the California Secretary of State, and have an active California employer account number under which employees are listed for payroll. The deadline to apply is May 31st, 2024, or until funds run out. And I can tell you that right now there is a waiting list for employers to apply. And businesses that have or contract with a PEO, a professional employer organization. So these are normally like your ADPs of the world that do or administer payroll, HR, safety, workers' compensation for employers. Those businesses that use a PEO, unfortunately, are not eligible for purposes of benefiting from the grant. Any questions, Annie, in regards to?
No, there are no questions in the chat right now.
Okay, great. All right, we did see a couple laws and updates on workplace safety. SB 1044, effective January 1st, prohibits employers from threatening or taking adverse action against an employee for refusing to report to or for leaving the workplace if the employee believes or has a reasonable belief that the workplace is unsafe. It also prohibits the employer not allowing a worker to use a mobile device or other communication device to get assistance, to assess a situation's safety, or to communicate with someone to verify their safety. However, it does provide that employees are required to notify their employer in advance, if feasible, if not as soon as possible, of when they are feeling unsafe. And for purposes of this law, an emergency condition is defined as conditions of disaster or extreme peril to the safety of persons or property at the workplace caused by natural forces or criminal act. And then 2, in order to evacuate a workplace, worksite, worker's home, or the school of a worker's child due to a natural forces or criminal act. One thing I can think of that will fall under this would be, for example, like like a scenario of an active shooter, anything like that, that would fall under the law. I'm glad that also the law defines that a pandemic is not considered an emergency condition under the law. Otherwise, we would be having everybody leaving the workplace or not reporting to the workplace. There are a few exceptions to the law for some industries, in particular for the healthcare industry and disaster service workers, among a few others as well. For COVID-19, we did see an update to several requirements that were in place or were put in place during the pandemic. Previously, employers were required to provide notice to an employee of a case exposure to COVID-19 within 1 day of exposure, or 1 day of the employer finding out. Now, to satisfy the notice requirements, employers can post a notice for up to 15 days in the same place that they would post like the regular employee posters or notices to notify the employees of a COVID-19 case. They still have to include the dates of the infectious period. And employers, good news is employers are no longer required to report cases to the local health department. And this law extends the notice requirements to January 1st of 2024. This requirement was actually due to expire January 1st of this year, but this law did extend it 1 more year there. We did see also an update to Cal OSHA's emergency temporary standard. This has been in place since November of 2020, and Cal OSHA actually now adopted a non-emergency temporary standard to actually blend in with their injury and illness prevention plan that every employer is required to have. So employers are no longer required to have a separate COVID-19 prevention plan to satisfy the requirement of providing protocols and policies and procedures for employees to comply with COVID-19 requirements. So this non-emergency temporary standard replaces the emergency standard that had been in place since November of 2020. It went into effect February 3rd, and it's in place until February 3rd of 2025. Applies to all employers as the same with the COVID-19 prevention program that had been applying to all employers. And a lot of the requirements now align with the California Department of Public Health. Previously, we had to deal with different requirements from the CDPH and also from Cal OSHA, also from the state. So this is like in harmony with everything that is in place with the California Department of Public Health, which is great news for employers. Employers are still required to report major outbreaks, though, and employee death and serious illnesses to Cal OSHA, as has always been a requirement. And the changes we're going to see with this non-emergency temporary standard is that, as I mentioned, the standalone COVID-19 prevention plan is no longer required. Instead, employers can roll their procedures and protocols into their injury and illness prevention program. If an employer does want to keep their COVID-19 prevention plan, their CPP, they can do so, but they're not required to keep it separate. The good news too is that exclusion paid has been removed. Previously, the emergency temporary standard required that whenever an employee was excluded from the workplace due to a COVID-19 exposure or being a positive COVID-19 case, they had to provide exclusion pay to the employee for the time that they were out from work. Now, this non-emergency temporary standard removes that requirement, and still employers need to provide testing in the workplace and during work hours for employees who are close contact in the workplace for COVID-19 purposes. What did not change from the law is that employers are still required to investigate COVID-19 cases. They must include the positive test and the dates of positive test and symptoms. They must still maintain effective protocols and policies to prevent the spread of COVID-19 and protect their workers. And the close contact definition stays the same. It had changed on and off throughout the different versions of the emergency temporary standard, but for now it's staying the same. So close contact is defined as someone sharing indoor space for workplaces with less than 400,000 cubic square feet. And then for keeping a close contact is within 6 feet or more than 15 for more than 15 minutes for those workplaces with more than 400,000 cubic square feet of distance. And again, free testing should be available for those close contacts in the workplace. Annie, I'll check in with you for any questions.
Yes, we have one from Rebecca. Did you say that the CalSavers regulation applies to businesses with one or more employee?
Yes, that is correct.
Okay,
Yes.
all right. So
That is
that's the only
correct.
question we have in the chat so far. Hope that answers Rebecca's question.
Okay, perfect. Okay, so we did see a couple laws that went into effect in regards to discrimination. We have AB 2188 that goes into effect January 1 of 2024, which basically is providing protection for employees or applicants based on their use of marijuana off the job and away from the workplace. Employees are still not allowed to be impaired or use marijuana on the job or possess marijuana on the job, so to violate an employer's anti-drug policy. So basically, this is going to become a protected category for employers to include with their policies. The other law that we did see is creating another protected category as well for an employer applicant to protect them for discrimination based on reproductive health making decisions. So that is also going to become a protected category, the same as race, age, gender. That's something else that does need to be included in there. And this one goes into effect January 1 of 2023. And with that, I would wrap it up and open up for any questions. Just a few notices. Every Wednesday, we do have Small Biz Talk conducted by Lori Williams, who is our financial guru here with the SBDC. So every Wednesday at 10 a.m., she has great topics that she covers for small businesses and guest speakers. Small business owners also can request to be featured on the show as well. And then if you do have an Instagram account, you can follow us at Pasadena SBDC. And I will now open it up for any questions, Annie.
All right, great. We currently don't have any questions in the chat, but that was a great presentation. We can give it a few more minutes if anyone has any questions that come to mind. And if not, oh, Rebecca has raised her hand. Rebecca, did you want to?
Yeah, my question is there like a place online, if we want more information on these regulations, is there a place online that we can look them up?
Yeah, you can access the Department of Industrial Relations website, and they actually would have information about most of the employment laws here in California.
Thank you.
You're very welcome.
Annie, this is Judy. I have someone that's trying to get in. It's a Dr. Dawn Muta Davis. She's a medical doctor. I will give her your information and maybe she can speak directly to you.
Okay.
She has to leave.
Okay, not a problem.
Mhm.
Okay. And I know Alfred was asking if a PowerPoint of the Zoom will be available afterwards. We typically don't share the PowerPoint for this particular presentation, but we will have a recording, and I will share that with everyone who's attended today. I will email that to you.
Yeah, and one thing to keep in mind is that a lot of these regulations also change from time to time, and that is the reason why we don't provide the slides, because what applies today may not apply next month. As was the case, for example, with the emergency temporary standard for COVID-19, we did have an update February 3rd this month. So that is how quickly some of the laws evolve and change, and some of the requirements. So for those reasons, we don't provide the slides, but if you have any questions about anything, feel free to reach out, and I would be more than happy to walk you through any requirements or any particular situations you are dealing with.
Thank you, Xiomara. And I'm going to add our email address in the chat as well. That makes it easier. So if you have any questions for Xiomara, email us here. If you're not already a client of the Pasadena SBDC, we can help you with that as well. But we do provide no cost one-on-one advising. Xiomara is one of our excellent advisors, and she can help you one-on-one with your particular HR questions. All right. So we do not have any more questions. We can leave it at that. Thank you everyone for attending today.
Thank you,
We
everybody.
are so happy that we can provide this information to you all. Thank you, Judy, for assisting us and for helping us host this wonderful webinar.
Yes, thank you, Annie and Xiomara. This is very informative. And as much information as we can receive from you will be greatly appreciated. And as Donald Lowe has indicated, any events that come up that can be virtual, please let us know.
We will.
Okay, or in person, because it may have to come to that.
Yeah.
Yeah.
Absolutely.
Okay.
All right, Judy, and I will send you also a copy of the recording as well.
Okay, thank you. Thank you very much.
Thank you, everybody. Have a nice day.
Thank you so much. This was helpful.
Yes, thank
You're
you.
very welcome. Thank you. Take care, everyone.
Okay, bye-bye.